Hello, my name is Jonathan Naylor. I'm an attorney here at the Castle Law Firm. Whenever clients come in to discuss child custody, the conversation normally turns to one of ex parte orders. Now, what exactly is an ex parte order? Simply put, an ex parte order is an order that is entered by a judge without notice given to the opposing party. Now, the key phrase here is without notice. Normally, in our justice system, a person is entitled to reasonable notice to appear and defend themselves before the court can enter a judgment affecting that person's rights, such as their rights to their children. However, an ex parte is done almost under cover of darkness. A person can be awakened in the middle of the night to a sheriff knocking at their door to take their children away without having had any kind of warning that this is happening in the first place. It's for this reason that judges are very hesitant to grant ex partes in the first place, and even then it can only be done under limited circumstances. In North Carolina, there are two types of ex parte orders affecting child custody, and they're both provided for under NC Gen Stat 50-13.5D. The first of which is a status quo order. A status quo order is an order that merely directs the parties to, you guessed it, maintain the status quo. Whatever the parties were doing initially before one party decided to act unilaterally, such as by withholding the children improperly, they are ordered to maintain the previous living arrangement. Ex parte changing child custody, however, is subject to a much higher burden. An emergency ex parte that changes a child's living arrangement can only be granted by a judge in one of three circumstances. 1, there's a substantial risk of bodily injury to the child. 2, there's a substantial risk of sexual abuse to the child. Or 3, there's a substantial risk that a party will kidnap the child or otherwise try to remove the child from the state. Unless one of these issues exists, a judge will not grant an ex parte. It's a high burden, but again, the law jealously protects a person's right to notice of a hearing affecting their rights and their right to appear and defend themselves. Now, if a party is able to prove to a judge's satisfaction that one of these circumstances exists, then an ex parte order changing the child's living arrangement can be granted. However, the opposing party is still entitled to a hearing. Once an ex parte order is granted, the opposing party receives notice and a hearing must be held within 10 days to determine if the emergency actually exists or if the ex parte order should be terminated. While ex parte orders are normally hard to get, nonetheless, emergency situations do exist that affects the health and the welfare of your children. If you believe that someone is placing your children at risk, you should pursue every legal remedy available to you to make sure that they're safe and provided for. If you have any questions regarding ex parte orders or you believe that this situation may apply to you, we here at the Castle Law Firm are here to help. If you have any questions regarding a criminal defense or family law matter, please comment below or send us an email at castlelawfirmqa@gmail.com. That's castlelawfirmqa@gmail.com. Thank you.